Welcome to Nuts and Bolts of Protecting Your IP. I'm Ala Castro, CLE advisor for the Beverly Hills Bar Association, and today I'm delighted to introduce our speakers, Elizabeth Manno, Manny Caixeiro, and Rebecca Horton of Venable LLP. Elizabeth focuses on technology disputes, including patent infringement, licensing, trade secrets, and other IP litigation. Elizabeth represents leading companies in technology fields, including media streaming, software, semiconductors, GPS, wireless devices, Internet of Things, artificial intelligence, and medical software. She also counsels companies on creating, maintaining, and maximizing the benefits of their IP portfolios. With her holistic approach, Elizabeth provides a steady hand and sound advice at every phase of disputes. Manny represents industry leaders and cutting-edge companies in their most challenging litigation matters. Manny focuses on complex commercial and intellectual property disputes across a range of industries, including software, medical devices, financial services, and entertainment. He has extensive experience litigating issues involving patent damages, valuations, and licensing on behalf of both plaintiffs and defendants. Rebecca helps clients protect their intellectual property and brands. Rebecca is a skilled litigator who advises clients on the protection and enforcement of their IP rights. She serves clients across a broad range of industries, including technology, financial services, and consumer goods and retail. Rebecca handles high-stakes litigation involving trademarks, copyright, patents, and trade secrets. Super Lawyers has repeatedly selected Rebecca as a rising star in the intellectual property space. She is also a frequent speaker at conferences and contributor to legal publications related to IP issues. We can't wait what they have to share with us today.
Thank you so much for those introductions, and thank you everyone for joining. We're really excited to speak to you today about the nuts and bolts of protecting our IP. So we have a presentation that we'll pull up, but over our years of practice, we've all really, I think, come to appreciate just how important IP can be to a company's business strategy. So we're excited to talk to you today about that, and hopefully you'll have the answer to this question about why you should care about IP by the end of it. But at a very high level, your clients and the companies you work for work very hard to come up with innovations, creative work, art, and branding. And so it's important to protect those things as part of your business strategy. Otherwise, you are risking losing out on some of the value that your companies are creating. So next slide, please. So we want to talk kind of about the different ways that you can protect your IP, and then we're going to also talk a little bit about how you can maybe decide between which type of protection is important. So the first one, if we can go to the next slide, is patents. So you've probably heard of a patent before. They come up a lot, but basically a patent gives you the right to exclude others from making or using or selling your invention for a limited period of years. It's usually about 20 years. And in exchange for that, you are going to publicly share your invention so that patents become public, anyone can access them, but you get the right to exclude anyone else from practicing that technology for that period of time. So that's sort of the trade-off there. And so there's pros and cons to that, but there's a lot of benefits. The benefit is you get to monopolize the market in a legal way. You can be the only company that is able to practice that technology. And patents are a licensable, I guess, item. You can, sell that technology, allow others to use it if they pay you a fee. So it provides a revenue stream if you want to do that. And patents are, for that reason, part of a valuation of any company. So whether you're a startup or an established company, your patent portfolio is something that you're able to license, you can sell them, and it's a potential revenue stream. And it's also, because of that, an asset that you can leverage. It's something that you can set up as collateral or use to gain more funding if you need it, that kind of thing. So it can be a benefit in that way. And then it can also just be a defensive arsenal, really, for your company to have patents. There's plenty of companies out there that have a very big patent portfolio, but they're not licensing it or suing anyone on those patents, and they're using it more as a defensive mechanism. So other companies are deterred from coming after them for patent infringement because of the large portfolios they have. So we could do a whole presentation on this, but there's lots of benefits and things that you can do with patents. So if we could go to the next slide. You may be thinking patents, sound like something that only tech companies should worry about, but it's really almost every industry, every type of technology or company has some form of patents. And so since we're in Beverly Hills, we thought it was appropriate to mention some of the patents that have been at the center for Hollywood for a long time. So again, it's not just the tech companies. Things like, the projection devices early on in Hollywood were very important and kind of shaped the industry in a lot of ways. And there were patents on this, so that has been integral in that industry. And I think really you'd be hard pressed to find any industry of any kind that doesn't have some form of patents or technology that have been central to it. I mean, and most companies now, for example, have a website, so there's everyone's using technology in some way. Next slide, please. And these are just some more examples of some of the patents we've seen in Hollywood. This is a very old 1930 patent drawing that we're seeing here, about an invention for measuring film. So again, it's not just tech companies that can have patents or come up against them. It's really pretty much any industry, including Hollywood. Next slide, please. So the other alternative of a way you can protect inventions is a trade secret. And you do kind of have to decide between a patent and a trade secret. And we'll talk a little bit more later about how you might decide that. Because a trade secret, as the name suggests, is something that is kept secret. Whereas I mentioned earlier, a patent, you're going to have to disclose that information to the patent office and eventually the public. So you do kind of have to decide which path you want to take. But a trade secret can be any sort of information that derives independent economic value from not being known and is the subject of efforts that are reasonable to maintain the secrecy. So what that means is this is not just any sort of confidential information. It really has to be something that you can prove, derives economic value, actual dollars, from not being known, and that you have made efforts to keep it secret. Next slide, please. And so there has been kind of for a long time, a patchwork of trade secret laws across different states. And those state laws still exist, but the federal law has now come into play as of 2016, the Defense of Trade Secrets Act. And this is the definition of trade secrets from that. And so that's really sort of changed since then over those years, changed the face of trade secret litigation and how it's managed with that federal act. If you could go to the next slide, please. So a trade secret, again, it can cover a wide range of things, just like patents, but it's, I think, actually even broader than patent protection. So that's another consideration. But, of course, you often think of, formula, the formula for Coke or things like that. But it can also be, the compilation of information. It can be a business plan. It could be your client or supplier list. We see a lot of litigation over client lists in different industries. So it's even broader than the type of protection you can get from a patent. And it doesn't have to be something necessarily novel, the way that you would have to show in a patent case. So that's another difference. Next slide, please. So this is sort of the pros and cons of trade secrets and patents. As I mentioned, you sort of have to pick between one or the other what you want to do to cover your invention. So we'll start with trade secrets. The pros of trade secret is that you don't have to disclose it to anyone. With a patent, you're going to have to disclose it to the patent office and eventually the public. You don't have to do that with a trade secret. And you also don't have to be something that you are proving is the first time anyone has done it, the way you have to with a patent. And there's no limit on time for trade secrets. You can keep them indefinitely as long as you're keeping them secret and meeting all the requirements of it. Whereas with a patent, you get a limited number of years that you have the patent protection. And trade secrets also don't have, I don't want to say no cost, but it's lower cost in that you don't have to pay filing fees to the Patent and Trademark Office the way you do for patents or trademarks or other items. But there are internal costs because, as we were discussing, you have to keep it secret and you have to put in time and effort, internal cost to do that. The downside of a trade secret is that process. You have to constantly monitor and ensure that you're not disclosing your trade secret, that you have the proper employee agreements and things in place. We'll talk a little bit more about that later. But there is work that you have to do on that. Whereas with a patent, you don't have to spend that effort to keep things secret. And a trade secret can't prevent reverse engineering. It only helps you if someone has, it protects you if like an employee were to take your information to another company and that's how they do it. But if a completely separate company decides to reverse engineer your product, a trade secret isn't going to help you if they didn't get it from you. Whereas a patent, it doesn't matter where they got the information or how. I mean, it can matter in some ways, but you don't have to prove that they got it from you. A patent, if someone's practicing it, whether or not they knew you were doing it, you're able to you're able to protect your invention and get them to stop making your patented product. And trade secrets can just be a little bit difficult to prove at times. In trial, there's a lot of litigation over, were you doing enough to keep it secret? What exactly is the secret? It can't just be, all of your business plans. So it can be a little bit challenging to prove in litigation as the plaintiff. And then you also have to show actual harm in a trade secret case. Your damages have to be tied to, what you lost from the trade secret being taken. Whereas in a patent case, you don't necessarily have to prove lost profits or anything like that. In a patent case, you're entitled to a reasonable royalty just off the bat. So you don't have to show that you actually had actual losses from the infringement, whereas in a trade secret case, you do. So then the pros and cons of a patent are basically the flip side of that. You can exclude anyone, whether or not they get the information from you, but it's for a more limited period of time. You don't have to monitor disclosure and make sure you're keeping it secret. So that can make it a little easier sometimes to deal with vendors and other suppliers and even employees, because you don't have to worry so much about a secrecy requirement. And like I mentioned, you're entitled to damages, whether or not you've lost any of actual losses based on the infringement. But the downside is it's a limited time period. You are required to disclose it publicly, so people are eventually going to be able to use your invention for free. And you do have to prove novelty. It does have to be something that's truly novel for the first time. And it can be a little more expensive in that you have prosecution fees and regular maintenance fees you're going to have to pay the Patent and Trademark Office. But again, the trade-off is, very high value ability to exclude anyone for a very long period of time, within the jurisdiction of the United States. So if we can go to the next slide, I'm going to turn it over now to my partner, Manny, to kind of talk about, okay, so how do you decide, which of these is right for you? So I'll let you take it over, Manny.
Great. Thanks, Elizabeth. Appreciate it. And hi, everyone. Again, I'm Manny Caixeiro. I practice locally here in Century City. And, I do a lot of litigation. And in connection with that, also a lot of advising companies about how they make some of these decisions on a practical level about, what is the best way to go about protecting their innovation. And, what's the most cost effective and budget friendly way to do that. On the screen, you'll see a list of considerations that a company is going to want to think about. And I don't want to repeat some of the things that Elizabeth said, but I do want to call attention to a few factors that I've seen it in a practical world matter to companies. And the first really is budget, because the process of obtaining a patent involves upfront cost. You're going to need to hire an attorney. Usually getting a patent is a protracted back and forth with the patent office, and you're going to have more upfront investment, as opposed to a trade secret doesn't really require monetary investment to establish the IP. You just need to have effective protocols in place to define and protect the secrecy of the trade secret, which we'll talk about how you would go about doing that. The next factor I often pay attention to is this question of, do you want to enforce against competitors? In other words, are you establishing this IP in a defensive way, in which case, trade secret can be a very effective way to protect your IP? Or from the outset, is your view that you want to enforce your monopoly and you intend to go after people who may be practicing your invention? Well, in that situation, patents offer some significant advantages. We'll talk about this in a little bit, but perhaps the most significant advantage is that patent infringement occurs regardless of the infringer's intent. It's the mere practicing of the patented technology or method or use of the patented technology that establishes infringement, regardless of whether the other side even, knows about your patent or when they were developing their product or ever meant to infringe your patent. As opposed to trade secrets, which really tend to have to be able to show that the defendant obtained access to your trade secret, and it was that access that led to the benefit the defendant is receiving, as opposed to, for example, the defendant just innocently inventing something on their own. An innocent invention can be patent infringement. It generally will not be trade secret misappropriation. And the other thing to think about is international enforcement. You know, patents, U.S. patents only go as far as the U.S. border. Trade secrets, as long as, depending on the state law and the jurisdiction, you can cover international misappropriation in some circumstances. I will say that one of the things that is becoming increasingly common in the world of patents is enforcement campaigns and portfolio development on an international level. So most sophisticated companies are not only obtaining U.S. patents, they're obtaining patents in other jurisdictions, including most notably the EU and Brazil. So while a U.S. patent may not solve your patent problem from an international perspective, international analogs to a U.S. patent may. We can go to the next slide, please. So let's talk about a patent portfolio for a minute, because one of the mistakes that I see companies commonly make is a philosophy that they want to obtain a patent on everything. And this is, as you might expect, needlessly expensive. And the result is a lot of patents that may not be protecting anything that the company is using and may not have any application of what's in the market at all. A much more cost-effective and efficient approach is to have a patent harvesting strategy that focuses on both core products and the products that you anticipate are going to get traction in the market, and the most important features of those products. Now, one of the reasons that this is important is to reduce the maintenance fees, reduce the prosecution fees. Now, the good news here is that one of the features of a patent and one of the advantages of a patent over a trade secret is that there is a secondary market for patents. And one of the things that we spend a lot of time doing with clients who may have too many patents or patents in the wrong areas of their product line is you can work to sell those patents. They're marketable assets. Trade secrets are not, because you would lose the secrecy in the process of doing that. That then comes to another important thing to consider about patents is, when on a transactional level, when you're acquiring a company, when you're selling a company, when you're considering an investment, when you're seeking financing, making sure that the valuation of a patent is accurate. And this is challenging. There is no bright line, scientific, black and white way to put a valuation on a portfolio. It's inherently a subjective view. And here is where, having done the work on the front end when you're establishing your portfolio, making sure that your patents are actually valuable, if you're the seller, if you're seeking the financing, that's going to be important. And equally important, if you're the buyer, not necessarily taking the seller's word for it and having an established way to really be able to diligence that properly, because those can be key assets in a company. And the other thing is, when a company doesn't work out and you're winding up or there's bankruptcy, often patents are the last valuable asset that a company may have, and it could be a way to ensure that you maximize and extract the last bits of value out of a failed company. We can go to the next slide, please. Now, a trade secret portfolio is different, right? A patent portfolio, if you go to a sophisticated company, they can literally pull up a spreadsheet and show you their patent portfolio. Most companies rarely do that with trade secrets for a few good reasons. One is one is not so much a good reason, it's a practical reason. They haven't done the work to identify all of their trade secrets. But the good reason is that sometimes it's hard to figure out what the trade secrets are. And it's only when the rubber meets the road and you're seeing a competitor start to use a trade secret, do you realize that this was a trade secret to begin with. So one of the struggles in relying on trade secret is you do need to be constantly monitoring, querying, auditing your people to make sure that you're identifying what the trade secrets are. Because as Elizabeth said, the key to enforcing a trade secret is showing that you took reasonable steps to protect the secrecy. And so if you haven't done that, if you haven't even identified it, much less have you put in the right protections to protect the secrecy, you may lose enforcement of the trade secret. To give you a war story on this, a few years back, I went to a client and we were having a discussion along these lines. And we came to the question of, well, what are your trade secrets? And they said, the formula for product X. So I said, okay, well, what is the formula for product X? And they pointed out to the hallway, and there was literally on a placard with the formula for product X without any sort of disclaimer or confidentiality. And so I had to advise them that it may be challenging to enforce this as a trade secret, given that everybody who walked through your hallway has now seen this formula. So as I mentioned, while you may not have the upfront outside legal spend on a trade secret portfolio as you'd have with a patent portfolio, it does require more internal diligence. And places where this manifests is in employment agreements. You're making sure that there's appropriate confidentiality, and in jurisdictions where it's allowed, post-employment confidentiality and restrictive covenants. Make sure that there's training on to the employees about how they should treat trade secrets, have a policy for it. And then, third-party agreements, make sure that could be a variety of things, but if you're working with a co-manufacturer, if you're working with a service provider, this is one of the ways that often trade secrets lose their enforcement, because a company gives access to a service provider to their trade secret, assuming that the service provider is going to maintain the confidentiality, but there actually may not be that obligation, or at least not that specific heightened obligation as you would need for a trade secret. And you could lose a trade secret protection through a third party that way. And then, IT systems and safeguards. This to me really goes to make sure that you're not inadvertently losing trade secrets because you haven't set up the right technology to protect your internal emails, your slats, whatever you have, from being discovered. If we go to the next slide, please.
Yeah, I was just going to chime in too. I mean, in litigation, these things Manny is talking about is the primary issue litigated. Like, did you do enough? So if you're planning to enforce your trade secrets and rely on that instead of a patent, you really need to have a good plan for that to tell the jury what you did. Otherwise, you may risk losing and you don't have a trade secret, which is obviously devastating. And then also on that piece, I think when you're looking at third-party agreements, it's a huge sort of umbrella of the variety. It could be end-user agreements. It could be, in the different types of agreements too, like NDAs when you're exploring opportunities and whatnot. So to Manny Elizabeth's point, it might seem like a lot of work up front to sort of do a revamp, but then at the back end, right, probably exponentially more thankful that those safeguards were in place, because it's easier to do it preemptively than after the fact.
100%. Good points, Elizabeth and Rebecca. So turning back for a minute to patents. Okay, so you have your patent. The next question that's often going to come up is, well, how do I know if somebody is infringing my patent, and what does that require? So patent infringement occurs, once you've obtained your patent, whenever someone has made, used, sold, or imported something that practices all of the elements of a claim of a patent. And I'm just going to break that down for 1 second. A patent is often a long document, but the most important part comes at the very end of a patent, where there are a list of numbered paragraphs that are called the claims. And the claims actually define what you have your patent on. So most of the patent is just providing context and background for what's called the claims at the end. And the way you infringe a patent is if you go to one of the claims, let's say claim 1, and claim 1 requires A, B, and C. If somebody out there is doing A and B and C, they infringe your patent, regardless of whether they knew they were doing all those things. Importantly, if somebody is just doing A and C, they are not infringing your patent. And that often is the battleground on one of the main battlegrounds on patent infringement. Another major issue, which we're not going to get into too much detail today, is whether your patent was ever truly valid such that it should have been granted. And what that There are a number of ways to invalidate a patent, but the most common and way that is fought is the idea that you were not the person, you being the person holding the patent. The defendant will say you were not the person who really invented this invention, that somebody before that either invented this exact invention or that this invention that you have a patent on was obvious to people who were in the field earlier. When assigning value to a patent, as I mentioned before, it's subjective. And in the end, the real value to any given patent is no more or no less than the amount of damages you can obtain against the world for people who are infringing the patent. And, I mean, by which is to say, patents don't automatically generate money on their own. They have to be enforced. Generally, the way to measure damages in a patent infringement case is a reasonable royalty. And this gets very complicated, but ultimately what you do is there's this hypothetical construct that both sides will get into that will argue what the parties would have agreed to as a reasonable royalty had they been willing to enter into a hypothetical negotiation at the time the infringement began. In some cases, you receive, and actually pausing there, as you can imagine, that is abstract, that's hypothetical, it's often fought out, and you need good experienced experts, good experienced litigators who know how to navigate these issues, because we've had cases where even if you're, as a defendant, even if you're found to infringe, if you can win this royalty battle and show that the value of this patent was low, well, I'd argue you won the litigation, right? Right. Paying $1 for infringing is not a bad business outcome.
There was a recent case. Sorry. I was going to say, there's a recent case here in the Central District of California where that exact thing happened. There was infringement, but $1 was the damages. And obviously that's pretty much a win for the defendant.
Exactly. Now, there are circumstances where you can receive more. In competitor cases, you can receive lost profits, which tends to be a higher measure of damages. And injunctions are possible. Particularly in competitor cases. Now, because of some case law that's developed from the Supreme Court over the last 20 years, injunctions are less frequent in the U.S. than in other jurisdictions. But there is a push to reestablish injunctions as a common remedy. And notably in other countries, especially in Europe and especially in some South American countries, injunctions are very common. So that's why we're seeing on a global level, companies look for international patents, and some of the enforcement is shifting away from the U.S. and to these other jurisdictions where injunctions are more common. Again, you can also get interest, and one concept also to be aware of is that, as I mentioned, infringement doesn't have to be intentional for it to occur, but if it is intentional, if there's willful infringement, damages can be trebled at the discretion of the court. It's rare, but it's possible. You can go to the next slide, please. So, one of the trends that we're seeing in the patent world is that, look, in general, like any other sophisticated commercial litigation, there's not a ton of trials in the patent world, but there are more than you might think, and they are increasing. And one of the key factors here is venue. If you talk to anybody who's engaged in patent litigation, probably the first thing they will talk to you about is the Eastern District of Texas and the Western District of Texas, which are two venues where, for a lot of reasons, they've established some very patentee-friendly rules, some patentee-friendly precedent, and perhaps most important for a lot of patentees, a very fast time to trial, and a sort of a philosophy that most issues should be tried rather than resolved on summary judgment or resolved by the court. So there is, if you find yourself facing a lawsuit in the Eastern District of Texas or the Western District of Texas, you need to recognize that. You need to recognize that if you don't have some really excellent legal defenses that can convince maybe some judges who are not inclined to dismiss a patent cases that should be dismissed, that you may very well be on track for a trial in one of those jurisdictions. We can go to the next slide, please. Now, one of the biggest misconceptions out there about patents is that they are enforced and litigated, and the world of patents is a competitor's world. In other words, I opened an ice cream store and there's another ice cream store down the block. I should be able to enforce my patent on ice cream against my competitor down the block. And that's very fair. And that's very free market economy. It's what we all think of as sort of, at the backbone of the way we think of economy and property rights in the United States. The reality of patent litigation in today's world is very different. As you can see here, 88% of high technology patent litigation involves a patent plaintiff that is a non-practicing entity, sometimes known as an NPE, and derogatorily referred to as a patent troll. Now, there are lots of varieties of NPEs, and I don't think it's fair to call all of them patent trolls. But the general common denominator here is you're talking about companies that aren't competing in the industry. They exist to monetize, license, enforce patents. And that is what most patent litigation is. And look, that could take one flavor of that is, a company that's got a few patents. They know they're no good, but they know that if they go and threaten the world, they can extract small settlements from a lot of different people. And that's a business model. And that's what people traditionally think of as trolling. But at the other extreme, and especially over the last 10 or 15 years, you see very sophisticated non-practicing entities working with litigation finance companies to establish large portfolios of thousands of patents. And they are not out to get quick hit settlements. They are out to make big money at trial. So circling back to something I said earlier, though, if you are getting patents, these MPEs also need to buy patents from somewhere. And it's another reason why having a good, thoughtful approach to getting patents can help you make money and help your company, because even if you're not using it, you can monetize in a number of ways. If we can go to the next slide, please. Again, patent litigation realities, simple point here. Most of these cases do settle, but in certain jurisdictions, that's less common. We go to the next slide. Now, trade secret litigation is a little bit of a different beast. You don't see this Texas issue. You see much more enforcement in Los Angeles, in Chicago, in New York. Often trade secret disputes are, in my experience, they're rarely just brought as a pure trade secret dispute. Usually there's some other business or employment dispute that the trade secret dispute is wrapped into, right? Like, your employee left, stole your secrets, you're enforcing a restrictive covenant against them, but also a trade secret case. Or, you're bringing an unfair competition case against a competitor, and along with that, you're making trade secret claims. So they tend to be less standalone and more part of complex disputes between companies. And that's one of the reasons why, if your goal is to enforce from the beginning, patents are kind of an easier way to do that, because a patent dispute has less stuff around it, and trade secrets tend to have a lot more issues. We go to the next slide, please. Okay, what would a CLE in 2025 be if we didn't talk at least briefly about AI? And just a few concepts here to hit on. One is that you can get patents on technical innovations that lead to AI models and AI techniques. You can even, for instance, one thing I was looking into yesterday was deep faking. There are patents on getting deep fakes, or patents on detecting deep fakes. However, some of the rules that currently exist is that an inventor of a patent cannot be AI. It has to be a natural person, and an invention is maybe patentable if it's made with the assistance of AI, but the natural person has to significantly contribute to that invention. Another note here is that, in general, the output of AI is not going to be patentable. However, it may, in a closed system, be a trade secret. So that's another thing to consider. We go to the next slide. Here, I'm not going to get into a lot of detail, but suffice it to say that we are seeing a little bit of a sea change in the Trump administration when it comes around innovation and protecting innovation. We are seeing a lot of people in the Trump administration, including the Secretary of Commerce, with an extensive history of licensing and enforcing IP, and a philosophy that supports that. We're seeing a rollback on some of the procedures and substantive defenses that defendants have used recently to defend against patent infringement. And we're seeing notably, the next last bullet point here, there's a real push to restore injunctions as a significant remedy for patent infringement in the United States. One of the rationales, which you can debate on this, is, well, if we're not doing that, other countries are clearly using injunctions to protect their IP, and are we falling behind other countries when we don't do that? There is a lot of back and forth you can go on this. Suffice it to say, as a result of these changes in momentum, it is a better time than it has ever been to obtain, develop, monetize your patent portfolio, because you're seeing a lot of the barriers and obstacles that previously existed come down. And conversely, it's a precarious time if you are in an industry where you're likely to be sued for patent infringement, because a lot of the defenses that have become standard playbook are being questioned. So with that, I'm going to hand this off to my friend Rebecca to talk a little bit about some other IP concepts.
Thanks, Saul. If we can go to the next slide. All right, copyright is another IP asset that you can have. It is a copyrightable work is an original work of authorship that is fixed in a tangible medium of expression. Some parts of that might make sense. The fixation piece sometimes can cause some questions. That if we take, for example, a song, it can be considered fixed if it's recorded, when it's recorded, or when the composition is written down. A common question then is, what is not a copyright? Sometimes it's easier to figure out what is not a copyright than what is. And so the Copyright Office is pretty clear on that. You can't copyright an idea, a procedure, process, methods. This by no means is a exhaustive list, but with the caveat that although, for example, an idea might not be protectable, the expression of an idea may be. But I think, as you saw from the earlier part of this presentation on patents, right? For example, although something might not be copyrightable, there might be something like another form of protection available, like patent protection. All right, next slide. All right, copyrights too have played a central role in Hollywood. We see Thomas Edison again back in the early 1900s when he was doing adaptations and duplications of theatrical works. In the early 1900s, we also saw theft of vaudeville material, which led to, not surprisingly, law firms trying to capitalize and monetize on that and advertising their services to help protect authors against that theft. You'll see on this slide one such example of that advertisement, and indicating that a copyright will protect you from pirates. So then throughout the 1900s, you see sort of evolution. We have the Copyright Act from 1909, but the one that you're probably most familiar with is the one that was passed in 1976. And that often is the foundation of a lot of the copyright infringement claims and actions and cases that you hear from today. And in the 90s then, with this sort of rise of the digital age, there was also a rise in piracy. And then we saw in the late 90s the passage of the Digital Millennium Copyright Act, otherwise known as the DMCA. And I'll talk a little bit more about sort of the nuances of protections that are provided under the DMCA. Next slide. All right, there are a variety of copyrights available in the entertainment space. Once again, not an exhaustive list. Illustrative, for sure. But one thing that can be interesting about this is that a work might have multiple types of copyrights that are applicable. So back to that example of a song, the recording, the song itself might be is typically copyrightable, as is the musical composition. And we've seen a lot of things come up in the daily news. Everything, extends beyond the industry press into sort of the daily news about, big artists either re-recording their music so that they can own it, or buying back their records and the composition so as to be able to own it. Next slide. All right, practical tips when it comes to registering copyright works. A question that we get, and it's understandable question, is in copyright, protection attaches upon fixation of the copyrightable work. So, right, that example of once it's written down or it's recorded. So then it naturally begs the question: why register? Why go through that process? Well, there's a number of advantages that come with it. First of all, it can serve as proof of ownership that you are the author of that copyright. It also provides you the ability to enforce those copyright acts. You are not able to bring a copyright infringement action unless you have a registered copyright. And also longevity. So for a lot of copyrights, it affords, once that copyright has been registered, it affords protection for the life of the author plus 70 years. And then, as Manny and Elizabeth previously talked about, it also can serve as a valuable asset that can be leveraged, in addition to sort of help with a sort of broader, more international IP portfolio building as well. Disadvantages, sure, there's some administrative requirements like the cost and if we're renewing the copyright. And one thing that can cause, it's a little bit more nuanced, is the requirement that you provide a copy of that copyright, of the work you're seeking to copyright, and then that is maintained by the U.S. Library of Congress. So for things like, for example, software code, that sometimes requires you to submit a certain amount of pages. And then if there are trade secrets provided in the pages you're submitting, then you can, then it sort of adjusts how many pages have to be provided to satisfy that requirement. All right, next slide, please. Copyright infringement and defenses. So essentially very similar in the sense of patent infringement. When someone violates one of the exclusive rights of a copyright owner, you can bring an infringement claim, or they may be liable for infringement. It has a certain amount of elements that you have to plausibly allege at the beginning of the case or prove at the end. Common issues that come up in copyright infringement cases can be whether or not the alleged infringer had permission to use that work. So for example, if there was a license, right, were they just operating within the scope of their license, or were they exceeding it? And then also whether or not the infringing work is substantially similar to the copyrighted work. There's also theories of secondary liability that you see in copyright as well. So not the primary, the primary party infringing, but somehow involved in the process. And then there's also criminal infringement under the statute as well, as is the DMCA, which provides some additional remedies for things like, for example, it provides the process for notice and takedown when someone's infringing your copyright, as addition to addressing issues where people circumvent security protocols to get access to copyrighted work, or are somehow altering your copyright management information of your work.
Rebecca, we got a question in the chat from someone. Do you need to register a copyright to bring an action in the U.S. or just register to get additional damages?
You need to register a copyright to bring a case in the U.S. And then also it also opens up the opportunity for obviously the damages associated with it. There are common defenses as well. Manny and Elizabeth talked about these as well, but there is the fair use defense, which I think we are all hearing a lot about. And in the most basic summary of it, it's whether or not the use of the alleged infringer was actually fair. Courts, and so effectively they didn't have to ask permission or provide money in order to use the copyrighted work. And courts look at a variety of factors for that in terms of the purpose and character of the work, of the infringing work, the kind of original work. Was it sort of more factual or creative? The amount and substantiality of the copying, and then the harm in the marketplace, or the potential harm for the copyright owner. And we'll talk about a little bit more about recent developments in that space in a few slides. Next slide, please. Available remedies for copyright infringement. There are, once again, these are some of the ones that we saw in the patent space, and actually we'll also see in the trademark space too. Another interesting remedy that can be available for copyrighted works, for example, pirated copyrighted works, is impoundment and destruction of those pirated works. All right, next slide, please. Copyright litigation and reality trends that we're seeing, not similar to other forms of IP litigation and also just generally litigation, most cases settle, but they can be time consuming and costly. So for example, there is these metrics, these median times were pulled from copyright cases since 2009 that have since resolved, and the sort of average time it takes to get to each stage. So for example, it could take at least 796 days to get to trial. So it's definitely not a short dispute by any means. There are alternative routes to bring your copyright claims, for example, before the Copyright Claims Board. There are some distinctions here, though. For example, there's limited jurisdiction over the types of claims that you can bring before the Claims Board, in addition to there being a cap on damages and oftentimes no injunctive relief unless the parties were to agree to it in settlement. All right, next slide, please.
Rebecca, we've got another, if I can jump in with another question. Someone asks, how do you prevent or combat a false copyright strike? So I guess when someone's claiming copyright that they don't really have, do you have any recommendations on that?
I mean, I guess if they're claiming it in the beginning, right, the pre-litigation stage, right, then you ask them to show evidence of copyright ownership, right? And that could be something like there could be a registration, right? But then they're not the owner or the sufficiency of the license if there was sort of or assignment of the copyright. So, I mean, if there's something as basic as, this is not something, you don't have a copyright registration for it, or evidence of its, it being, you're the first to sort of create that expression, right? And then sort of evidence of it being fixed, right? When was it recorded, right? When was it written down? That sort of thing. If you get into litigation, right, then it's going to be an issue that oftentimes could come up in the context of the beginning stages of litigation. So the motion to dismiss stage, and that would be oftentimes an argument made, is that you're not even the owner of the copyrighted work, or you don't have standing to bring it. All right, judicial and regulatory developments. As Manny said, what would be a CLE unless we talk about AI? And I could spend an hour and longer talking about developments in the copyright infringement and AI space. So there are in excess of 40 cases alleging copyright or involving copyright infringement and AI tools. And we've reached, some of those cases have reached a dispositive point. So a couple of weeks ago, we got 2 decisions out of the Northern District of California, finding in favor of fair use, but they reached those decisions slightly differently in terms of how they find that the doctrine applies to AI tools, in addition to certain fact patterns that might have a different outcome, which is very interesting. And then we'll see, I think we anticipate before the close of the year, some additional dispositive rulings coming down and, not surprisingly, likely appealed. So we're going to see that working its way up. There are also a lot of regulatory developments as well. The Copyright Office has been busy. They have issued 3 reports covering various areas of major issues at the intersection of copyright and AI. One of their reports was about digital replicas of people's images and likeness. So Manny had talked earlier about that term deepfake. And so we're seeing, so the first report covered that. There was a report about the copyrightability of AI generated works. Similar to sort of what we're looking at, we see kind of in the patent space as well. Works completely generated by AI are not copyrightable, but works that are generated with the assistance of AI may be, depending on the scope and extent in which the AI tool was used to generate that work. And then also we saw a report on the use of copyrighted works in the development of generative AI tools. These reports are very lengthy, but they are interesting in the sense that the Copyright Office solicited public comment in drafting these reports, and includes some summary of some of those public comments, both from industry leaders and participants to academics, the general public. And then the Copyright Office also in those reports indicated some of where it stood on potential issues as well. But we're not quite sure whether or not those positions on those issues are, set in stone, because there has been some changes in the Copyright Office. As we all know, with this administration, there have been a lot of employment shakeups, and that has also impacted the Copyright Office as well. Currently, there is no Register of Copyrights. The Register of Copyrights is the person that signs the copyright registration. And so as a result, copyright registrations are currently going out without a signature. And there is a discussion currently as to whether an open discussion as the validity of those copyright registrations that we're seeing sort of ongoing right now. I recently checked the Copyright Office website, though, and they're very aware of that public discourse, because there's a lot of, I think it's in their facts section and Q&A, but there's a lot of sort of response saying that, these copyright registrations are still valid, even absent the signature. In Congress as well, there's a number of acts currently going through involving copyrights and AI, both, directly on in terms of disclosure of creation and alteration of data sets that use copyrighted work, and then in addition to a number of acts involving deepfakes as well. I'm not going to go through each one, but there's a number of things happening currently, and it's changing in real time. All right, next slide. Protecting your brand. All right, so this is another area IP asset. It's another way of another form of IP protection. That's a trademark. A trademark is a source indicator that identifies and distinguishes the source of goods or services of one party or the brand from those of the other in the marketplace. Depending on how you define it, it can be word marks. It can be sort of, there are things like word marks. There are design marks. You hear terms like house marks, service marks, that sort of thing. A word mark would be, as you can imagine, a word itself, whereas a design mark might be, for example, a logo. So, a brand name and the design elements around it. What are the benefits of trademark protection and trademark registration? It is a form of protection for the brand identity. The rights can last indefinitely. Once again, it can be an asset to leverage as well. And there's actually common law rights that are associated with a trademark, in addition to federal rights that are associated with a federal registration as well. And then, we were able to find this image of Venable's trademark certificate there, which amazingly likely passed our conflicts check. All right, next slide. Trademarks have also played a central role in Hollywood as well. I won't go through sort of each of the steps, and certainly this is not an exhaustive list of the timeline, but essentially, as you can imagine, as theatrical works and movies and films became incredibly, increasingly more available and to the public, and then monetized, for example, with like merchandising and whatnot, that you can see that then there became an increased need to protect the brand associated with these, characters, films, TV, and music as well. And you saw a focus on, seeking formal protection, federal protection for those marks. In addition to, in the 80s, you started seeing more leveraging of trademark law, not only by sort of companies and corporations, but by individuals as well. And also extending into areas like protecting a likeness or a catchphrase. And we'll talk a little bit more about protecting sort of the image and likeness as a brand protection strategy in a second. Next slide. Trademarks in entertainment and retail, there are a number of them. Once again, we sort of talked about some of the traditional trademarks, like a word, a phrase, a symbol, a design, that sort of thing. There are a number of non-traditional trademarks, though, for scent, sound, color, motion, and once again, sort of the crux of it is whether or not it serves as a source identifier. So if you think about, for example, the opening credits of a movie, right, you'll see credits for a studio, a production company, and you might see an animation that you associate with a certain brand or a sound, right? And some companies have sought and obtained trademarks for that animation and that sound. Next slide, please. Practical tips for registering trademarks and some considerations, right? Previously, I mentioned there's common law rights. So you don't have to register a trademark to have trademark protection. So then that begs the question, why seek federal registration for a mark? Or you can also seek state, you can register trademarks on the state level as well. A federal registration affords nationwide rights. And then it also can serve as a presumption of ownership and validity of the mark. There are additional types of legal claims that can be brought. And then also some of the additional things that we talked about earlier with other types of IP. It can be a valuable asset. It can assist in foreign registrations. Disadvantages, there's some, administrative requirements as there is for any formal filing of IP. One aspect of it is trademark application can be time consuming. I think the USPTO currently estimates that it takes on average 12 to 18 months to receive a trademark registration. Next slide, please. All right, so as I promised, under that umbrella of brand protection, there's trademarks, and another area is the right of publicity. And that is the right of an individual to control the economic use and exploitation of their identity. It varies by state, but they define identity as an individual's name, image, and likeness. So this is another form of protection. Sometimes you see it in state law protected under, considered or framed as a right of publicity. In other areas, it's a right of privacy. And this has some relationships to other IP. There is no registration system in place. It is primarily governed by state law. And there's some overlap. It can overlap with trademark protection as well. And I'm not a graphic designer, but that design on the side was intended to be that, those college pennants, those felt flags. I realized that should never be my primary job as a graphic designer. But I think, Manny, you had some insight as well in terms of what we're seeing sort of in the name, image, and likeness space and how that's sort of relating to deep fakes as well. Manny, you're on.
Right. Yeah, I would say, just for the interest of time, that this issue of deep fakes and name, image, and likeness, there's a trademark angle to it. There's an obvious copyright angle too, to the extent, you're using a registered name, and image, and likeness. And there's a lot of action on the patent side too. I saw recently there are companies getting patents on both methods to create deepfakes and methods to detect deepfakes. And one of the really interesting things on it from a patent perspective will be how enforceable any of that is, because, one concept in patent law is that if something's abstract, if you could do it on your own, just using a computer to do it doesn't make it patentable. And a lot of these deepfake patents and deepfake detection patents, I think, are going to raise interesting questions about, are they enforceable at all?
Thanks, Manny. All right, next slide. I won't go through every step, but once again, there are certain elements to establishing or proving trademark infringement. Oftentimes, the common and big issue is whether or not there's actual or a likelihood of confusion by consumers between the source of goods and services. But unlike with copyright, right, you can bring a trademark infringement claim based off of unregistered marks or federally registered marks, or a combination of both. Let's go to the next slide. The remedies as well, as on a high level, categorically, there's some similarities to the other remedies available in other forms of IP. This is sort of a slide. This chart is depicting trademark awards that have happened in cases since 2009. It obviously does not capture settlement agreements, because oftentimes any sort of monetary money exchange in the course of those is confidential. But it's interesting too that you see, for example, statutory damages are more than actual damages or infringer profits. And And then there are statutory damages available in addition to for issues like counterfeited marks or improper domain name registration. And there's the potential for trebling of damages like that we heard Manny talk about as it relates to patent damages. And we've seen awards anywhere from they stand out, but anywhere from 50 million up into the 100 million for trademark infringement cases. All right, next slide, please. All right, judicial and regulatory developments. Once again, we cannot escape AI, and nor do we want to. There are certain AI infringement cases or AI cases that also involve trademark infringement as well. There's copyright infringement claims, but there's also trademark infringement claims. One of those cases, for example, is Getty Images. It's actually pending in both the U.S. and the U.K. And that case actually has already gone to trial, and they're waiting on a decision. So that will be definitely interesting to see how that comes out. And these other cases are at their earlier stage, but they involve, for example, an AI generated image alleged to have been based off of a film, and that it was used in a promotional event. And there's allegations that creates a false impression of endorsement by the film company of the company that's using or running that promotional event. And then there's also a case, Advanced Local Media, that involves a number of claims, but it's premised on output from an AI tool, and that some of the output is falsely attributing incorrect content to certain news and magazine publishers as well. See a lot of sort of developments in the trademark, a lot of discussion in the trademark space also as it applies to social media in terms of whether or not you can get trademark protection for domain names. Also we see, and there are some domain names that do have trademarks or companies that own domain names that have trademarks on those domains. We also see it there are some trademarks for hashtags and social media handles. A lot of times the question really comes down to whether or not that, for example, hashtag or social media handle is being used as a brand or source identifier versus, for example, in the context of hashtags, it's just an organizational or search tool that you're seeing. And then we're also seeing it in the counterfeit and third-party retail sites. So there have been some recent decision in the Southern District of New York involving a third-party retail site and the marketing and selling of goods on that site and the use of the brand and whether or not that was authorized or endorsed. And so that's sort of causing a lot of discussions for the companies that are involved in third-party retail. And then as we previously talked about, Manny talked about as well, name, image, and likeness. It's something that you're hearing a lot in the daily news in addition to industry news with, for example, college athletes now being able to monetize their name, image, and likeness. And then also as it relates to all the legislation currently underway or in process as it relates to deep fakes. All right, I've been talking for a while, so I'm going to turn it over to Manny and Elizabeth to close us out.
Yeah, so we're short on time. So I think our takeaway for all of you would be, that you should be strategic about IP. This should be something that's part of your business plan, just like any other part of a business plan. If we can go to the next slide, we've provided in the materials some links to some additional information if you want to learn more about any of these concepts. And we all love to talk about it, so our contact information is in there too. So feel free to reach out. And we did have a few questions in the chat. We can hang around and answer those if people want to hear them. But we understand that you all have very busy days too. So thank you all for joining. We appreciate the opportunities to present, and we'll chat about some questions. But I understand if people need to hop off as well. So thank you. So one of the questions we got was, how would anyone know if AI was used in patent development, which is a great question, because as we mentioned, an AI can't be an inventor. When you apply for a patent, there's all kinds of disclosures you have to make, and there's a duty of candor. So you're going to have to identify an inventor. That's going to have to be a human being, and they're going to have to sign declarations and things like that. And then if you get into litigation, there is absolutely a lot of discovery and depositions and things about what we call conception and reduction to practice. So whoever owns a patent is going to have to explain exactly how they conceived and came up with the invention. So that would be the time where, if you're facing patent infringement and you think that this was created by AI, you would absolutely get to probe that and sort of demonstrate how, or discover that AI was involved. So, I mean, it would not be a good idea to lie to the patent office. I suppose it's possible, but that would certainly come out. Okay, another question we got was, are there any special issues on these for nonprofits that you've seen in your practice? From my view, nonprofits can hold patents. A big thing that comes to mind to me is for universities. A lot of universities obviously have a lot of inventions and technology that they patent. And so really it's the same rules as for anything else. But I don't know, Rebecca and Manny, if you have any thoughts on any distinctions or things to be aware of in that space.
No, it's the same in trademark and copyright as well. Pursuing it and then also protecting it, I think a lot, especially like, for example, in the trademark space, right? The goodwill that can be associated with a nonprofit, it can then be very important to protect that because that's, the reputation and the general sort of perception of your company, of your nonprofit, right, is critical and important as well. So we definitely see a number of nonprofits trademarking either their sort of over their house mark or, their goods and services and what they're doing.
And Elizabeth, where my mind went on that was from the defense side, just being a nonprofit is not going to insulate you from potentially infringing. And so where my mind went on that is the issue will become indemnification. Is if you're a nonprofit, I think you're going to want to make sure that, to the extent you're using software services from other companies, that you've thought through your indemnification provisions and don't find yourself on the hook for essentially somebody else's infringement.
That's a great point because I've definitely, in the trademark context, I've seen nonprofits be targeted too. So you do need to be very cautious when you're coming up with your branding and things like that, especially for newer nonprofits. Okay, copyright question. Do any states still have common law copyright protection for works that are in a tangible medium of expression? For example, a stand-up comic who runs through his routine at a comedy club but has not recorded it or written down.
There's no common law protection for copyrights. It's a federal IP right. So unfortunately, no, but there might be creative. So for example, like, right, once it's sort of fixed, I guess the protection is there. But I guess what I mean is more so that you can't sort of enforce that if somebody were to sort of take that. And then sort of as a general matter, right, there is not the common law right. So we're just looking on the federal level. I think that would really come down to what is fixation. And I think I would have to, like, on that issue you're looking, there's access to it, but it's not recorded or written down. I think that would get into the nuances of what is considered fixation, right? And I think it might be very, specific to the scenario and the context, right? So that would be something that you'd want to sort of discuss about exactly sort of what happened, right? To figure out if you can, if there's some sort of flexibility there in that fixation outside of the sort of traditional norms of it being sort of recorded or written down.
Okay. And then this is a follow-up question on the false strike issue we talked about. I think I think the question is maybe more like if your work is being removed from a platform, I guess based on a claim of copyright infringement, but you think that's incorrect. Is there any way that you can do something about that if you don't believe it's copyright infringement? And I think the answer may be you have to go through whatever takedown process, which is probably not a helpful one. But I don't know if you have any tips on that, Rebecca.
Yeah, I think, well, there's there's the formal process, right? If you were sort of end up in court, but a lot of platforms have, policies in place for like counter notifications, for example. So sort of essentially like combating that sort of that the takedown notice that was submitted. And then also the ability to contact directly the claimant to ask them to sort of retract the claim. A lot of this is sort of, efforts to either formally with the platform itself or also directly with the claimant to sort of avoid the dispute that's going on or sort of resolve the dispute. Copyright strikes on some of the platforms do have an expiration, right? So I guess you could wait out that expiration, but oftentimes that can be understandably not of interest. So those are some of the alternative routes that are available outside of the sort of formal context of litigation.
All right, and last question, and I think this is also for you, Rebecca. Is there a process you recommend to transfer a copyright from one entity to another in addition to any recordation of the transfer?
a robust written agreement in place. So obviously, I think as this person noted, that it does need to be recorded with. It doesn't have to be, but it should be recorded with the Copyright Office. But I think also relatedly is that sort of underlying that is a written agreement which outlines the sort of the transfer of the ownership, the specific rights that are being assigned over, being transferred over, any sort of additional aspects to that agreement, if there's sort of an exchange of money, that sort of thing. That's going to be something where you're going to want an underlying written agreement as well.
Yeah, so that's all the questions we had. Thank you for those are great questions. So again, we appreciate everyone joining today. Happy to chat further, take a look at the materials, and we hope you all will now answer the question of why IP should matter. Thanks, everyone.
Thanks.